did PW 44 and 45, and their team recovered it. At the time that they recovered it, it was in the house of the fourth accused. The radio was neatly packed in its box, complete with its wrappings and the nylon film used to protect the screen when it is new. It is therefore not true that the first accused, what the first accused said, that he and his team used that gadget for their work. Now, 4, after being in each of the 5 sites or lock-in core of the murders, the radio, which is Exhibit 25, was captured at Valley View Estate between 22:20 and 22:40 hours on the night of 23rd and 24th June 2016. Now, Valley View Estate is where the first accused, the house of the first accused was. So where he lived with his family at the time. And then 5, the first accused was carrying the radio, Exhibit 25, on the 1st of July 2016, when he was arrested at Flying Squad offices where he had been summoned. And lastly, since the first accused said that he was the one who had the radio, Exhibit 36, on the morning of 24th of June 2016, when he left it charging in the office, how did it get to the house of the fourth accused? In its box, wrapped as new, complete with the protective film on the screen, and yet the fourth accused was away between the night of 22nd of June and 27th of June 2016. How did it get to the house of the fourth accused? Now, the evidence of the police radio phone trajectory detailing the movement of the radio P Exhibit 25 on the 23rd of June and the evidence of its recovery from the first accused 9 days later all show that the first accused, as in charge of SPIV and in line with the accountability protocol of accountable gadgets like police radio phones, had custody of the radio phone and had used it exclusively at all the 5 lock-in core at the time the offenses were committed. The prosecution proved that the radio issued to the first accused by defense witness number 10 was never put to use. So I find that, as the radio indicated, the first accused was at the Mlolongo police station on the 23rd of June 2016. He proceeded to Mavoko Law Courts, then to Syokimau Post, to Soweto later that evening, where the deceased were all murdered, and to Klimambogo through the Superhighway to dump the bodies of the 3 deceased persons before returning to fetch his co-accused at his bar in Mlolongo for work well done. Now, I consider the first accused defense, the evidence of his witnesses. I find that the prosecution has established that it is the first accused who had the motive to harm the second deceased in this case, because as a result of the complaint he made against him at IPOA, his job was on the line. The first accused may have gone to Uhuru camp to help his sister-in-law in the morning of the 23rd. However, from then on, the evidence is overwhelming that he personally attended to ensure that the deceased persons were captured, they were detained to await nightfall, they were murdered, and their bodies dumped or flung into the river to make it difficult to ever recover them. His explanation about the radio phone, Exhibit 25, just as his alibi defense, is unreasonable, incredible, and is not plausible, and therefore I reject it in total. I have carefully considered the entire evidence adduced in this case by both sides, and I have considered the submissions by counsel the authorities relied upon, and having done so, I find that the circumstantial evidence established against the first, second, third, and fifth accused persons justify the drawing of an inference of guilt to the exclusion of any other reasonable hypothesis except that of guilt. I considered whether there were coexisting circumstances that could weaken the chain of the circumstances relied upon and found none, I am satisfied that there was no other reasonable hypothesis that can be made on the basis of the evidence before me except that of guilt. In the result, I find that for the fourth accused, his alibi defense has shaken the veracity of the evidence of the prosecution against him, being that of the fifth accused alone, and therefore I gave him the benefit of the doubt and acquit him of all the 3 counts of murder under Section 322 of the Criminal Procedure Code. For the first, second, third, and fifth accused, I'm satisfied the prosecution has proved the case against them beyond any reasonable doubt, and therefore I found them guilty of the 3 counts of murder, contrary to Section 203 of the Penal Code. I accordingly reject their defenses, find them guilty as charged, and convict them accordingly under Section 322 of the Criminal Procedure Code. Now, I also want to inform the first, second, third, and the fifth accused persons that they have a right of appeal within 14 days from today. And before I end, 2 things. I wish to register my gratitude to the Learned Prosecution Council, the Learned Councils for the defense, and the Learned Councils for the victims and the interested parties. And I thank you very much for your great support, your industry, and contribution to jurisprudence, and also for giving me an opportunity to complete this case. And I also thank the accused persons for allowing me to complete the case. At the beginning, it didn't look like it was going to happen. Now, I wish to end with a little story. There's a man who told his son that he wanted to teach him a new trade, so he asked him to follow him. They went to the neighbor's farm and stood next to a mango tree. The father told the son to look around as he climbed up to pluck some mangoes. He told him that his role was to look around, and if he saw anyone at all, to start running home, and his father would follow him to avoid arrest. So the young old man climbed the tree. After 5 or so minutes, the father saw his son running, so he climbed down quickly and followed him. After running for some time and seeing no one following them, the father stopped his son and asked him why he ran, telling him that he did not follow his instructions. So the son said, "No, but I did follow your instructions. I looked up and I saw God looking down on us, so I ran away." So that is the end.